Court calls the case of the people versus Cody Jolly. Hello, what's your name?
Cody Lee Jolly.
There was no counsel appointed.
How did that happen?
I was representing myself.
You're going to represent yourself?
Yes, Your Honor.
Okay, so what do you want to do today?
Is this pre-trial then?
This is a probable cause conference.
Probably.
That concerns me if you don't know that and they're going to represent
Yeah, I'm
yourself.
going to plead not guilty in this case.
Okay, you already entered a plea. What are you going to do at the hearing today?
At the hearing today,
Yes.
I'm just going to plead not guilty.
Okay, that's you've done that.
Right.
So what do you want to do with this case?
I mean, it's up to you. I'm not understanding.
No, you're not. It's not up to me.
Pleading not
Probably what
guilty,
you want to
take it
do.
to pre-trial.
Pardon?
My hope was to take it to pre-trial.
Well, the next stage would be a preliminary examination. Is that what you want?
Yes, Your Honor.
Do you know what that is?
Yes, Your Honor.
What is it?
The preliminary hearing.
Yeah.
It's another case similar to this, and then there's other options. If I'm seeking discovery, or if I'm seeking this, if I'm seeking that.
Oh,
For trial. Right.
Is there a reason you don't want to be represented by an attorney?
Yes, Your
Because
Honor.
I see this thing getting south real fast.
I've represented myself before, and I prefer to, Your Honor.
Have you requested discovery?
I have not.
Why not? You're here at probable cause conference. Why haven't you requested discovery?
For me, there was no issue. There was no conflict. There's no case. There's no case whatsoever.
You requested discovery. You know what discovery is?
Can I request?
Do you know what discovery is?
Yes, Your Honor.
What is it?
All the evidence in the case.
Okay, have you requested that from the people?
I have not.
Then how do you know there's nothing there?
Can I request a no?
You're going to have to do it in your own way to request it. I mean, I can't help you through this process.
Would you like it by mail?
Represent yourself.
I'd like to represent myself more.
Then you're going to have to request discovery.
Do you want me to request discovery?
I don't care what you do. I'm just telling you, if you're going to represent yourself, you're going to need to request discovery. You haven't even requested discovery.
I currently am right now. If you'd rather me do it by mail, I can do it by mail.
Well, there's a way in which you do it.
I understand. You got to file it to the circuit, or to the circuit court, to the prosecutor,
for Pete's sakes.
and also to the
No,
DES.
that is not how it happens.
In front of you, then, is the other.
No.
Okay, how does that happen then? Sure. Then
I'm not here to help you.
I understand.
I'm here to set the case.
I filed for case of study.
Okay, so here's what we're going to do. People have their witnesses available on the 12th?
We could try, Your Honor.
Well, you can at least start it.
Yes.
Okay. That's what we'll do.
He was made aware of his constitutional right to an attorney, and he's officially ready.
He was made aware of that before,
Just making sure that it's on there.
and he wishes to proceed forth. Is that correct, sir?
Yes, Your Honor.
You understand the dangers in representing yourself.
I do understand.
Did you want counsel to help you?
No, I do not. Not this time.
Your Honor, and just for the record, and so that defendant is aware, he is charged with 2 counts of criminal sexual conduct. That is a high court misdemeanor, punishable by up to 2 years and or $500.
You understand that, sir, right? Yeah, I'm going to do it. Let's not set it for prelim. Do you know how to, you don't even know how to go about getting the discovery on this case, do you? Do you want to talk to somebody about how to try to get your discovery on it?
I can honestly do it myself. If you'd like me to discover, I can file for discovery.
You don't even know how to do that.
Okay,
You know what you do to get discovery?
Before, usually when I file most, I file them by mail or in front of the judge, or I request a deed.
Okay, look. Trying to offer you somebody to talk to so they can show you how to get your discovery.
Yeah, but
Would you like to do that? So how do you intend on getting your discovery? Because you file a motion and you haven't requested it as a prosecutor. I'm not granting it. You're going to be wasting everybody's time.
Okay, so if you don't accept it by mail or in front of you, in what way would you prefer me to file for the motion?
Oh, for Pete's sakes.
Every judge is different, so
No, every judge in this county isn't different. Welcome to Washington.
I've been to Washington, I think. Fortunately. Yeah.
Would you like somebody to help you at least tell you how to get discovery in this
If
case?
someone wants to tell me, that'd be great, but I still prefer to represent myself for this.
I don't care if you represent yourself.
What's wrong?
I'm asking you because you have no discovery. You're going to walk into a preliminary examination
Yes, if you
and it's going to be a problem.
right. If you prefer it to be
I don't care.
Motion to be filed
I'm not,
differently,
it's not an
that's self-focused.
issue of my preference.
Okay.
I'm trying to get somebody to help you before you become an absolute disaster regarding this case. So I will make the offer again. Would you like to talk to somebody about how to get your discovery?
I would love to talk to him anyway.
Mr. Gaddy, will you please speak with this gentleman about how to get his discovery? I would appreciate it. Oh, I'm not passing. I'm just going to give a new date.
Oh, okay.
Because it's not going to come back up here before me, not today. I'll adjourn this matter to March 21st, 2023 for 9 a.m. Bond will continue.
Yes, Your Honor. I have a question for you, and I have a tether that's on that I can't afford. Is there any way that there was just because of stipulations of ROR? I'm wondering if it's possible to remove it.
To remove the tether?
Yes, Your Honor. Since I'm not a flight risk or anything, I'm just living in town.
Denied.
Yes, Your Honor.
Thank you. Bond will continue. Okay. So what o'clock? I'm gonna need a break. Even if it's just 5 minutes, court is taking a brief recess.
Cody Lee walked into a Michigan courtroom like a man with nothing to fear. Facing 2 counts of criminal sexual conduct, a high court misdemeanor carrying up to 2 years in prison and a $500 fine, he had made one bold decision: he would represent himself. No attorney. No help. Just Cody versus the entire justice system. The judge, clearly experienced with defendants like this, asked him calmly what he wanted to do at the probable cause conference. Cody said he wanted to plead not guilty and move to a preliminary examination. Fine. But then came the question that unraveled everything. Have you requested discovery? Silence. Cody hadn't. He didn't even fully understand what discovery was, the evidence the prosecution holds against him. Without it, he would walk into a preliminary examination completely blind, with no idea what witnesses or evidence the state had lined up to bury him. The judge's patience visibly thinned. She explained, then re-explained. She offered him someone to talk to, not to take over his case, just to show him how to file for discovery. Cody kept insisting he could do it himself. But every time she pressed him on how, he gave a different, vague, and frankly alarming answer. You don't even know how to get discovery on this case, the judge said bluntly. And she was right. Finally, she arranged for someone to walk Cody through the process and adjourned the case to November 21, 2023. His bond conditions, including a GPS tether he said he couldn't afford, remained firmly in place. Request denied. Cody came in confident. He left with a new court date, no discovery, and a judge who essentially called him a disaster waiting to happen. Would you have taken the lawyer? Tell us below. Backhand index pointing down.
And that brings this courtroom exchange to a close. The key issue was not simply that Cody chose to represent himself. It was whether he was actually prepared to do so. The judge confirmed that he understood his right to counsel and the risks of proceeding without an attorney. but his lack of discovery preparation quickly became the central problem. Discovery is critical because it allows a defendant to understand the evidence and information the prosecution may rely on. The judge ultimately arranged for someone to explain the process, adjourned the matter, and kept the existing bond conditions in place. She also denied Cody's request to remove the tether. One important note: the live courtroom exchange states a March 21st, 2023 adjournment date, while the later narration says November 21st, 2023. So those dates should be verified against the official court record. What do you think? Should Cody have accepted legal assistance from the beginning? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.